This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
GP, how are you today?
I'm well. How are you?
Very good. And I'm not going to, I've been suitably chastised for attempting to give you a nickname which you were not enthused about. And I won't even, we'll just leave it at, it was I thought it was kind of a clever play on a serial killer, and the whole kind of deal. You didn't take it in such good humor.
I think you sort of explained the problem yourself right there. You tried to nickname me after a serial killer. Yeah, I mean, look, do your best. Whatever. I thought the writing was lazy, but whatever.
Okay. So I'll do this since we haven't given out any swag in a while for best comment of the week. Best guess as to what and you'll never
no one's getting that, but I will say on the heels of my comment that your writing was lazy, I will say that your compatriot in this endeavor came up with the better version of it. Okay. There was alliteration involved at the very least, and I thought that was somewhat clever. But
it was clever. I'll give it that. So anybody who gets, and I guess there would be 4 words, anything having to do with Gary, take out. But if you hit any of the 4 monikers, then free swag.
Yeah, this is fantastic. If anyone can guess the derogatory nickname that Mark tried to give me, then I will have the added task of sending you free shit. We can't miss here, Mark. There's nothing about this that is flawed. It's not like I have 3 full-time jobs already. We should absolutely make more work for me in sending people free stuff for being derogatory towards me. Yeah, right, I see absolutely no flaws in this plan, Mark.
It's kind of a holistic approach.
Holistic. That's a way to put it. Sure.
So I didn't force you to curate this week. Our trusty researcher, a lawyer, man about states, Brett, came up with some stories today that I thought were fairly interesting, don't you?
I mean, I read through 2 or 3 of them. It did not alert me. I didn't see my inbox until just before you came on. But I thought that his curation was very well done. Yeah.
So and one that he didn't have, but I think, do you have the Amy Coney Barrett one? Because I thought that was an interesting take that Brett had on that. And the reason is I was reading before I did this, the Daily Journal, which is the publication here in California. And they did an article about our current Chief Justice, Patricia Guerrero, who is now being labeled the lone dissenter, which I'm old enough to remember. I love that expression. When Chief Justice Rehnquist was referred to on the U.S. Supreme Court as kind of the lone dissenter. And then there was a time when Clarence Thomas was thought of as kind of the lone dissenter. And it's interesting, just the evolution of time, how the dissents evolve into the majorities or a different way of thinking. And also was thinking about Scalia and how Scalia has single-handedly transformed Supreme Court jurisprudence. And when I say single-handedly, obviously I'm overstating it, but he really is kind of the godfather of the strict constructionist movement, which was then kind of embraced by Clarence Thomas and gone there. But the Amy Coney Barrett, you want to set that up for Brett's research?
Yeah, apparently she was doing a appearance and an interview with Barry Weiss, who is soon to be of CBS News, if the reporting is correct. And she was promoting her book, Listening to the Law, and she basically rejected the notion that the United States is in a crisis. She stated that the Constitution is alive and well, and that the true constitutional crisis would only exist if the rule of law crumbles, a threshold she doesn't think has been met. And she said that although there's, intense political polarization at the moment, especially under the Trump administration, she asserted that we do have functioning courts and the country remains committed to legal principles. She stated, quote, "I do think Americans should trust that the court is trying to get it right."
By the way, one personal take here is all, and it's only been 8 months of this administration so far, but all of the can I say, pearl clutching,
Yes.
and hair on fire. And I know I got into this
for the audience. Mark tends to come to me with for takes on whether or not his phrases, his idioms are still acceptable.
And idioms, yes, because, well, I am at the age. I was talking with another, I won't dime him out, but another trial lawyer of my generation, and we were laughing about the fact of how many times in front of a jury we'll say something that has a reference that is only 30 or 40 years, kind of in the past, and we get the blank stare. And so I'm constantly testing that.
The blank stare. I would think you would get the actual pearl clutching. The people, oh my goodness, how did he just? How did that just pass his lips?
But I remember a Two Angry Men where Harvey and I were having the argument, and he had thought, I forget the exact subject, but it was going to be the end of the world, civil war, whatever. And
it was the protests in LA, and it was the National Guard being deployed to Los Angeles.
Right. And then look what we've had. We did not break out as I expected because there is a process that we go to. In fact, this past week, I don't think this was on Brett's research, but one of the cases that I thought was interesting was the federal district court judge, brother of the former U.S. Supreme Court Judge Breyer, who ruled that some of these actions of the administration violate the Posse Comitatus Act, and that will make its way up the three-rung ladder, I'm sure, to the U.S. Supreme Court. And you have seen that there are points at which there has been even Trump-appointed Trump-appointed judges who have ruled against administration policies, and there's been the process. My feeling is when you're talking about the rule of law, that when there, and I know that I'm going to hear in the comments, we'll see, that when there is a blatant non-enforcement or compliance with the order where you go outside and there's a contempt proceeding and you violate and you just don't care and there's no enforcement mechanism, that's kind of the bright line for me.
Yeah, I don't think you'll have to go all the way to the comments to hear the complaints about that. I think you could just walk down the stairs, but but yes, anyone who's been following along on Los Angeles Magazine will see our coverage of that as well, because yes, the justice did rule that Trump's deployment of the National Guards to Los Angeles violated the Posse Comitatus Act, and that is certainly something that is, I would say, something for those who are concerned about the Trump administration to remain hopeful about. And I don't think that it got the coverage that it deserves, and I don't think that it is calming those who are on the other side of the aisle the way it should be. But I agree with you that the things like that are showing that there is still functionality and stopgaps for the perceived just, king-like power that Trump yields, it is, it's not there. The U.S. court system is not allowing it the way he is trying to wield it. I think that there's a perception by some that Trump is trying to do anything he can, which I think is the case, and that he is getting away with it and there's no pushback against it. And I don't think that's the case. I think Trump is trying to do anything he wants, but he is being stopped at times. And, there is pushback from the courts.
And by the way, a lot of the things that people said, this is obviously a bridge too far, the courts have not agreed with that on either side. And it's being worked out in the courts, which, by the way, is the law.
Yeah.
That's the way the law works. And you take it to the courts. And I know that guess I would characterize myself as worshiping at the altar of the law. And I have a great faith in the system that we can work it through and we can make the arguments and that people are going to listen. Are there outrages on the margins? Absolutely.
Of course there are. I don't think that's even debatable, but I agree with you. I think that as long as the courts keep functioning in this way, there is a reason to have faith that reasonability will be upheld and that there is not such cause for concern. I think the problem that we face here is that when the stopgaps are enacted, that's not covered the way the outrages that precede them are covered. And I think that's the problem.
Right. You call it a stopgap. I call it a speed bump or a guardrail, whatever you want to call it.
Sure.
Whenever they don't, because there is so much hysteria around the act itself when it's challenged. And by the way, I was reading an article about, and I know very well, obviously, from the defense of Hunter Biden, Abby Lowell left Winston Strawn, and Abby and his associate David Kolansky. I can't tell you how much how impressed I am with both of their legal abilities, their acumen, their strategic and tactical, and they both were at Winston Strawn when we were dealing with Hunter, and now Abby has started his own firm, Lowell and Associates, and has carved out this niche of kind of the pushing back on Trump. He's got as clients Tish James. He's got Lisa Cook, who, for those who aren't in the weeds, is the board of governor who's being accused or was fired for reasons of mortgage fraud, and Tish James, who I believe is in the crosshairs of TOJ on that. And Abby has carved out that niche where he is kind of the standard bearer of that. And I was also reading about Norm Eisen, who was an Obama era and also Biden era lawyer, who is now also kind of doing the kind of legal special ops opposition to various policies. And for those who kind of complain about that or whatever else, by the way, on the right, that was happening as well during the Biden administration, during the Obama administration. I can remember during the Clinton administration, Judicial Watch was doing many of these things. So that is, and it's now characterized as lawfare. I think lawfare, to my mind at least, has a slightly different characterization. It's more of a crossing of the line, so to speak, where you're using it for political purposes. This also is being used for ideological or political purposes, but I think it's the proper area or arena to fight in, as opposed to bringing criminal cases and things of that nature against your opponents, or invoking kinds of over the line tactics.
Yeah, I completely agree. I go back to the idea that the outrageous attempts are much sexier and more fun to write about by the media, and the more in the weeds legal stopgaps that come to follow 6 to 9 months down the road are less sexy and therefore covered less. And I think that that's really a function of why people are not necessarily as informed about the fact that things are working in the way that they were designed.
Yeah, that's exactly right. There was one other story Brett had that I really liked. Do you have it in front of you? And
is that the Gruden story?
Yeah, the Gruden story. Exactly.
Well, I think that I
also thought this was right up your alley.
Oh, it is. And this is as good a time as any to let you know that I'll be out of the office for a few days next week, because I'm going to be going to do some boots on the ground reporting at Raider Stadium to see if I can get some pull quotes from Gruden. But yeah, the Gruden case, it was ruled that he was not an employee of the NFL at the time. So therefore, it was outside of the NFL's purview. And Roger Goodell is not. I think the courts called it outrageous to suggest that Goodell should preside over this. And therefore, Gruden is available to go forward with his civil case against the league.
Yeah. This, by the way, this ruling makes so much sense and has been applied. The principles of it have been applied in other areas, and I will predict that this will also be used for other kinds of regulatory or administrative bodies. This is kind of a wave of challenges that we're going to see. And the idea of being adjudicating and also being the old expression, judge, jury, and executioner is no longer going to hold.
Yeah, I think that that's another point that Brent makes, and I think that it's probably correct, is that this calls into question a lot of arbitration clauses in different areas of contract law. So I think that this case is going to be substantial and consequential in more ways than people may think.
Right. And I think you're going to see it's going to go up the ladder more than it already has. And I think we're going to have it's going to become a seminal case, would be my belief.
Yeah, I think you're right. So I will be on the ground investigating.
That's your job, Gary.
All right. Sounds
and
good
to
me.
those to who, if anybody, by the way, not just swag if you get in the universe, if you nail one or the other, we're going to elevate the prize.
We're going to elevate the prize.
Yes.
Oh, that doesn't sound like more work for me. So great. Fantastic, Mark. Mark, thank you very much for making some time on this fine Sunday as you listen, Saturday as we record, and we will look forward to more next week.
Thanks, Gary. Good to see you.
You as well. Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/Reasonable Doubt Podcast.